Morning. Please be seated. This is the time set for oral argument in SARKILAHTI v. Bristol Group, our civil number 18-0255. Each side will have 20 minutes within which to present their argument. Appellant may reserve some portion of that for rebuttal. Mr. Abney, you can leave that to you as to how much time you wish to reserve. Keep an eye on the clock in that regard. We have read the briefs. We've been through the record. We've conferenced the case, so we're familiar with the underlying facts of the issues. We're recording the proceedings by audio and video. So as you approach the podium, please identify yourself and your clients for us. With that, Mr. Abney, you may proceed.
It's gathering warm already. May it please the court, my name is David Abney. I am here representing Wanda SARKILAHTI. I very much appreciate the opportunity for the oral argument. My basic premise is that you can look at something over and over and simply not appreciate that it's a danger. The Vouteurs lived at the home for a long time, the lessees, and saw the condition, surely, and simply did not appreciate what the condition meant. The commentary to the restatement third talks about the fact that what matters is your appreciation of the dangers of the condition, not simply that the condition is there at all. And that really matches what's going on with restatement section 368 out of the second restatement when it talks about the things that you can have which would make the lessor liable. And it talks about the lessee does not know or have reason to know of the condition or of the risk involved. Now, they knew there was a condition there.
Let me ask you a question. It intrigued me in the course of reviewing this, the court's approach to its factual findings, I suppose. It talks about the fact that in Piccoli, they lived there 2.5 years.
Right.
Here, they said, well, the Vouteurs?
Vouteurs. Well, I'll just call them the lessees. It might be easier.
That may be. They've been there for 4 years.
Yes.
So if the one had lived there 2.5 years, the other had been there 4 years, clearly the one that had been there 4 years would have recognized what the person that had been there 2.5 might not. I mean, do you understand what I'm talking about?
I do. I don't think the length of time matters a lot. What matters is, do you have...
That is my question. What does that factual determination do for us?
Well, it becomes a jury question. Could reasonable jurors say that this condition, you could look at it over and over, this uneven ramp step condition, and not appreciate that it is in fact a danger at all? You simply know that it's there. You don't pay any attention to it. You're not trained in building safety. You're not a lessor yourself. You've never really thought about it. It's just simply there, and you walk up. I probably just walked up the ramp back and forth. They didn't say that, but they both said they did not appreciate the danger. And that's just human nature. You can look at something, unless you've got special training, you won't realize that a step of 14 inches is more dangerous than a step of 8 inches, or that a slope step is even more dangerous than both of those, or that a combination of a ramp and a sloping step is even more dangerous than that. They simply had no appreciation of it. Now, jurors could say, hokey balokey, you live there forever, you ought to know that it's not only that it's there, but that it's dangerous. Other reasonable jurors could say, no, it would have never occurred to me.
So I'm trying to understand, Mr. Abney, in Picola, and I'm sure we'll be talking about this with Mr. Holohan, the defect there apparently was that the glass in the glass door was plate glass and not safety glass. That's
right.
The defect, and at least the appellate court observed that the resident knew that the door was not safety glass, or knew it was plate glass. So the defect was known.
Correct.
In that scenario.
Right.
Here, the defect, was that the step off from the porch to a sloping driveway is that enough, or does the tenant, lessee, have to appreciate that the defect creates an unreasonable risk?
I think they have to appreciate that there is a danger with it, not simply that there's a condition there. In Picola,
How do we square that with Picola?
well, I believe in Picola, if it wasn't exactly stated, the inference was they should have known that this plate glass was dangerous and should have done something about it, should have warned people there, certainly.
But isn't the whole concept of reasonableness a question of fact for
Yes, it is.
someone to decide, or is it a preliminary question as part of the duty analysis?
Well,
big question of law and fact.
There may be a case where you could say, I mean, Picola, I suppose, is one of those cases where you could say these people not only knew that there was a condition there, this uneven step, or in the Picola case that there was a plate glass door instead of a tempered glass or a safety glass, but they realized that it was a danger. Here, we don't have that realization. In fact, we have opposite testimony from both of the lessees that they did not appreciate that it was a danger at all. And
putting aside the husband's declaration, looking at the wife's declaration, was her simply saying, "It never occurred to me"? Is that enough to create a question, a genuine issue of fact?
under these circumstances, yes. And both of them combined makes it even more of a certainty that it's something that should go to the jury. And I wouldn't expect to win the case here before the court. I simply want to get this case back where it belongs, where reasonable jurors can take a look at this and say, okay, Picola strikes a very personal note with me. After my senior year in high school, I was at a friend's house for a swim party, and there was a glass door there, a sliding glass door. I walked right through it. And I still have the scar. I could show it to you if you want. I still have the scar to prove that I was that dumb.
Well, that won't be necessary.
Well, and it's just not a personal thing, but we all look at things every single day and not have an inkling that this is dangerous, and suddenly somebody else gets injured, or we see somebody, or we get hurt ourselves, and all of a sudden everything clicks into place. All the tumblers fall. And there we are. We finally appreciate it. This is one of those cases where the jurors could say, okay.
I didn't go back to look at the pleadings, but after the motion for summary judgment was filed and you responded, was there any request to defer resolution of the summary judgment in order to conduct discovery as to what the owner of the premises knew and whether they considered it a risk, or whether they had ever taken any steps to warn the lessee?
There were statements from the lessees, and I think they were deposed. There was expert reports. We had what is he called? A property management expert, and we had a forensic civil engineer experts talk about the codes and what the lessor should have done, should have known, that sort of thing. So there was a fair amount of factual material to deal with. And the most important thing being, I believe, is the declarations from the lessees about living there, and the fact that they didn't have any background in safety engineering or buildings or anything like that, and that they both said just very clearly, flat out, declarative sentences, we did not appreciate the danger.
Talk about the number of facts that were available, the body of facts, if you will, that were made in the course of getting to that point where the motion for summary judgment was filed. Did the court have factual support in the record, something that could be pointed to in regard to the facts that support his determination to grant summary judgment?
I'm going to say yes, and I'm going to qualify that immediately. There were enough facts there to reach a correct determination, being this is a jury question. There were plenty of facts there. How long they lived there, when they bought the place, that sort of thing.
Okay, and you just kind of surprised me with what you said, that it is a jury question.
It is a jury
enough
question.
Facts there to determine it was a jury question.
Oh, yes, Your Honor.
But the court didn't find that it was a jury question.
No, but everybody makes mistakes. That's why we're here.
There's some people who would disagree with you about their making mistakes, but...
Well, of course, I know the panel never makes mistakes, but other judges
I want to
do.
be clear. I mean, motion for summary judgment is a determination based upon the law, right? Application of the law to a given set of facts, a given...
Correct. But then again, you've got to look at the facts in the light most favorable to the non-moving party. You've got to take every single inference you reasonably can in favor of the non-moving party.
Were the facts that the court used in granting summary judgment the court's facts, or were they in the body of the factual statements that come about in the course of the litigation.
The fact had enough bricks and mortar to make the building, no question. There was enough information there for the judge to make a ruling.
From
the
the body of evidence in front of it.
I think so.
Okay.
But the ruling was incorrect, I submit to the court, because the conclusion should have been, after looking at these facts, well, this is a jury question. Now, I may personally believe, as if I were a jurist, I might say I may personally believe that these people should have known not only that there was a condition there that was dangerous, but you've got to keep there's a point where you have to keep an open mind, as you know, as a judge. You've got to say, well, maybe reasonable people, other people could disagree with me. And that's when it goes to the jury, and it's where it belongs in this particular case. I have no gripe against the judge. Is a smart person and dedicated, hardworking, all that stuff. I don't want to slam the judge at all, but everybody makes mistakes, and this is a judicial mistake. This should have gone to the jury.
You referenced earlier the third restatement, but is there any support that we have adopted the third restatement?
I don't think so. There may be. It seems sort of buzzing around the back of my mind that we have adopted or used that section before, but and I know for some reason the Court of Appeals and the Supreme Court especially have been very skittish about the third restatement. I think under either restatement, though, and if you went back to the first restatement, the result would be the same. That you've got to know not only there's a condition, but you've got to appreciate that the condition is a danger, not simply that you see it there and see, well, there's a condition, but to understand. And if you don't do that, then the lessor can indeed be liable. It's all a question of fact, though. What did the lessor know or should have known? What did the lessees know or should have known? The only person here I don't think you have to worry too much about is Wanda. She had no idea about this. This was her first visit to the house, and she's leaving to go back to her car, and boom, she's down and out and badly injured as a result of this.
Parked in the driveway?
I think she was parked in the driveway, yeah. But
she walked right by either stepped over it or walked around?
She may have seen it. Absolutely. I wouldn't contest that at all. And I can speechify all afternoon, or morning, but I'd rather sit down now, if I may.
Thank you, Mr. Adler.
Thank you.
We want to stop the clock.
If it pleases the court, I'm Brian Holohan. I represent the defendant Applee Bristol Group. Here is the point at which Mr. Abney and I part ways. He thinks the test is whether the landlord has to warn a tenant of a condition that is unreasonably dangerous, and that isn't the standard. Under the restatement, under Picola, even under the restatement third, it is more accurate to say that the landlord has to have reason to believe that the lessee will not discover the condition or that he will not realize the risk. In Picola, Mrs. Steinberg, the tenant, testified that, and this is from the case itself, based on her knowledge of construction and the age of the house, she did not think the door was made of safety glass. There wasn't any indication in this case that she knew or believed it was dangerous, just that it was a non-safety glass door. The court goes on to say, and this is at page 312 of the Arizona reports, we find that any duty to warn of or remedy the condition by making the door conspicuous had devolved upon the tenants. The tenants had been in possession under the lease for 2.5 years at the time of the accident, knew of the location of the Arcadia door, and correctly believed it to be made of non-tempered glass. It's because the tenant knew it wasn't safety glass that the landlord had no duty.
So that it was knowledge of the defect, in the words of the court, that then devolved the duty to warn on to the tenant.
Exactly. Remember,
so, let's presume for a minute there's a defect here, in this case, this driveway, porch, edge, slope is a defect of some fashion. What seems to be lacking is is an acknowledgement by either of the residents that they knew that was a defect.
Except that the word that the restatement in the cases uses condition, not defect.
Well, I'm referring to the language in Picola, since that's the case you're relying on.
We find that any duty to warn of or remedy the condition by making the door conspicuous had devolved upon the tenants. Whether the condition is known by the tenant to be dangerous is an alternative. It's not a requirement. It's either or. And in this case, these people lived in this house for 4 years. They knew what the porch, which by the way they own, looked like. They bought the house specifically because half of the porch is wheelchair accessible. Mr. Verteur is in a wheelchair. They knew what their porch looked like, and that's enough under both the restatement and Picola to absolve my client of any duty to them or any invitees on the property.
Counsel, I have a question for you. I would argue that plate glass and a concrete step don't have a whole lot in common. The plate glass you look at and you realize, I think, that glass breaks. To the extent that you know it's plate glass and not safety glass, you know it may shatter. Fair statement? I mean, does that make sense?
Judge, I think the key to Picola is that it was a glass door, and the tenant knew it was plate glass rather than safety glass, and that's the condition.
The concrete. Do you remember the days when we had the first bite being free in dog bite cases? Does someone have to get bit before there's liability? With this concrete, did someone need to fall in order to say, watch out, people have fallen there? Is that kind of notice necessary?
Evidently no, because the tenants got sued and had to pay her some money. But my client is the landlord. All we do is rent dirt and utilities hookup.
So was your client in a position where the list of horribles should have included, watch out, this is dangerous on this concrete? Does there need to be prior notice, or is it just an observation issue?
According to the restatement, the standard is whether my client had reason to believe that the lessee will not discover the condition or realize the risk. There's nothing in the record to suggest that my client shouldn't have thought that someone who lived in their house for 4 years would fail to appreciate that they have a porch, part of which has a step-off.
Is that, we're sort of now moving into sort of the reasonableness of your client's conduct, and does that, and the reasonableness of the lessee's conduct, is that not a factual question?
Not according to Picola. Remember, Picola affirmed summary judgment in the landlord's favor.
I'm familiar with the case.
And my client, the Verteurs, lived in their house for 4 years, not 2. And the issue is whether my client had reason to think they wouldn't discover that their porch in the house they've lived in 4 years has a step-off.
And so my question really, again, is, it sounds like there's a reasonableness analysis here, both on your client's obligations, whether they had reason to know or not know, and whether it was reasonable for the lessees to say, well, we didn't know.
Well, I have two responses. The second of which is there's nothing in the record about what my client did or didn't know or did or didn't believe. And so I don't know how on the state of this record one could conclude that we had reason not to think that the tenants would fail to appreciate it. But remember also, the motion was granted on the issue of duty, which is usually a question of law for the court. I understand there may be circumstances where some element of whether a duty arises goes to a jury, but this one seems pretty clear to me, and there isn't anything in this record to suggest that my client had reason to believe that the Verteurs would not discover the condition, which is the standard under the restatement.
Then your position is that if in Picola 2.5 years was enough opportunity to discover the dangerous the hazard of the glass, then in this case 4 years was even more so plenty of opportunity for the lessees to discover that this was a dangerous condition.
Yes, Your Honor. The other thing I come back to is the tenant in fact knew that the door was made of something other than safety glass, and that was enough to absolve the landlord of liability.
But we don't quite have that here, though, do we? Where the tenant in fact knows that this step could be dangerous.
No, and you're falling into Mr. Abney's trap, with all due respect. It's not whether they knew it was dangerous. It's whether they knew the condition existed. Remember,
Had plenty of opportunity to discover it.
exactly. This is a rule imposing liability on landlords for latent, hidden, concealed defects. This porch is out there, and maybe Mrs. SARKILAHTI didn't pay. Maybe she failed to appreciate the danger when she was walking off a porch she had just walked over, but the point is, my client has liability only if they lacked a reason to think that the voitures, after 4 years, would fail to understand that their front porch has this step-off. Let me address one last point, if I might. It's probably a throw-in by the plaintiff, but it was in the reply brief, so I want to address it, and that's this Arizona Mobile Park Residential Act claim. It was not an argument advanced by the lawyer in the court below. The reply brief suggests that it was in the layperson expert's report and therefore somehow was a legal argument. But I pulled the report, and in point of fact, the expert does not offer the opinion that there was a duty under the Arizona Mobile Home Act. The non-lawyer expert suggested there might have been a duty under the Arizona Landlord and Tenant Act, which, as we pointed out in the response, couldn't apply because this isn't a residential lease. The other problem with the plaintiff's position is that premises is a specifically defined term under the Mobile Home Park Act. It's defined in I have the subpart, but not the number. I apologize. I think it's 1409, but I can't be sure. But the subpart is 22, where it defines premises as the mobile home park and its existing facilities and appurtenances. In other words, the obligation to maintain a safe premises only applies to the public areas, not to any individual tenant's mobile home. So I just wanted to address that point. And unless there are other questions. Thank you.
Mr. Holohan.
Just a few comments. The restatement, section 358, talks about the lessee does not know or have reason to know of the condition or the risk involved. Either know the condition or have reason to know of the condition, or know the condition or have reason to know of the risk involved with that condition. And that's the crucial break there, the disjunctive nature of what they're saying here. It's you can know of the condition, or you can know, or you cannot know of the condition, or you cannot have no reason to know of the condition, or you cannot know of the risk, or you cannot have reason to know of the risk. There's two different things going on there, and that's enough to establish liability. As far as what the lessor knew or had reason to know, this is the lessor's lot. This is the lessor's pad. And as far as what they should expect the lessees to understand, there was specific evidence that the lessor never told the lessees that this was a danger, never told them that this condition could be a hazard to them, that it was in violation of the safety codes.
So how do we get around the fact that they had opportunity to discover it?
Oh, they had lots of opportunities to discover it, but what they discovered, they saw the condition. They didn't see the danger that went with the condition. There's a big difference there. You could see something every day and not realize it's a risk. And that's what happened here. They saw it regularly and didn't realize it was a risk. Although the husband didn't see it so much. Apparently he entered the building from the other side. He didn't go this particular way. But the wife, they would have seen it, sure, but they just didn't know what it meant. And that's why the restatement is in the disjunctive, because it recognizes that people can see things all the time and not realize they're dangerous. And the specific commentary actually to the restatement third talks about realizing the dangerousness of the condition. It was comment E, I think, to that section 53 of the restatement third. Once again, I've reached the point. Maybe you've fallen into my trap. If not, keeping talking won't push you forward into the trap. I'd love to answer any more questions. If not, I'd be happy to cede my time back to the court.
Thank you, Mr. Abney.
Thank you very much. Appreciate it.
We do appreciate the briefing and arguments presented on this matter. We'll take this under advisement and issue a ruling and written decision in due course. We're going to take a brief recess to allow the counsel for the next case to come forward and get set up if in fact they're ready to do so. We're a little early. We'll stand at recess.